Say your full name.
Charles Kennedy.
Kennedy, how are you?
Okay, sir. Ready to go home?
Ready to go home? That makes two of us.
Yes, sir.
All right, Mr. Kennedy, you had some traffic matters which you failed to appear in court for. As a result of your failure to appear, warrants for your arrest were issued. The court's going to set aside these arrest warrants, give you a personal bond in these misdemeanor matters that carries a maximum penalty of up to 93 days in jail and or a $500 fine. You have the right to remain silent. Anything you say you can and will be used against you. You have a right to an attorney. You can afford an attorney one way point of behalf. The tickets, Mr. Kennedy, are 475021 and 22. Driver license suspended. Unregistered motor vehicle. And 23, no insurance. As I indicated earlier, just put your finger down, sir. Just listen. You're giving a personal bond, no dollar amount in these matters. You're giving a pretrial court date of May 22nd in front of Judge Kennedy. Is that clear?
Yes.
All right, now to your main matter. This is case number 250-574-6101. Pearson and Miskin versus Charles Kennedy. Appearances, please.
Thank you, Magistrate. Steve Vincent for the people.
Jessica Scheib on behalf of Mr. Kennedy, who is formal reading understands his constitutional rights and stands mute.
All right, the court will on a not guilty plea on behalf of Mr. Kennedy. Mr. Vincent, are you requesting a remand in this matter?
Actually, Magistrate, in a unique set of circumstances, I'll stipulate to a cash bond, and I don't mean to be dramatic here, but I'm going to be asking for a $10 million cash bond. I want Chief Judge McConico to see this defendant in these allegations. I want him to analyze himself whether or not this defendant is a danger to the community. So I'm not going to be asking for a remand here. I think this is one of those cases where the chief would enjoy looking at all of this and doing the right thing here and putting whatever he feels an amount, probably even higher than $10 million, to be quite honest with you. We have a defendant who was previously convicted of a criminal sexual conduct in the first degree with a minor. And now we have allegations, quite honestly, these allegations are some of the sickest and grotesque that I've ever read. And the defendant allegedly, if he did do this, Magistrate, is one of the most perverse people that have ever come in front of this courtroom. We have the defendant allegedly, making a 6 and 8-year-old give him oral sex, him sexually penetrating the 6 and 8-year-old. We have the defendant making the 8-year-old use her mouth on the 6-year-old's genitalia.
Okay, Mr. Vincent.
And then, Magistrate, wait, let me just get this, and I appreciate you letting me do this.
Okay.
And then to entice them not to say anything for their silence, he either gives them candy or, in the alternative, doing 180 degrees, he tells the kids that he'll kill one of their family members if they say anything. So, Magistrate, you can do what you want with this. I kind of know where you're going to be going with it. But I quite honestly, I want this to go in front of Judge McConico.
All right, Ms. Scheib, your response.
Yeah, so let's make a couple things clear for the record. Number one, my client is presumed innocent unless proven guilty beyond a reasonable doubt. So these are all allegations, and he has not been convicted of this case that's in front of you right now, because he is presumed innocent unless proven guilty beyond a reasonable doubt, and not guilty until proven innocent, Your Honor. That's number one. And number two, my client's case, or him, or this whole situation is not for the amusement of anybody. So if the people think that he's a danger and needs a remand, then they can ask for that. If they think that he can get a cash bond, they can ask for that. But they shouldn't ask on numbers based on what, they want a chief judge or somebody else to be amused by the facts here or my client's case. My client at this time, when he stands in front of you, is innocent unless proven guilty beyond a reasonable doubt, no matter what the charges that he is facing are. So I asked the court to consider a cash bond GPS tether, in-house arrest. Any bond amount's going to be unaffordable. He's a lifelong resident. To my knowledge, he's not on probation or parole or anything pending. He's 40 years old. We obviously understand no contact, and I leave the rest up to the court. I'm not going to get into the fact details because we are here for arraignment, but I did want to make clear that, you know, if somebody is a danger and he's being charged with this and you want to ask for a remand, go ahead, but don't ask for things just for the amusement of somebody else. It's not right on my client's rights,
Okay.
Your Honor, no matter what the situation may be.
All right, the court have heard argument as to bond, and Ms. Shive, I agree with you on that. Either ask for a remand or cash bond, but not for the amusement or the personal satisfaction or gratification of any particular person.
I agree with that too, for the record.
Okay, all right, but under MCR 6.106, I will remand Mr. Kennedy in the custody of Wayne County Jail for a few reasons. I believe the kids talk that the reference in the investigator's report, I have no reason to doubt the sincerity of the complaining witnesses. And if these allegations are true, they're very, very egregious. More so, he has a previous conviction for criminal sexual conduct 3rd degree with a child under the age of 13 years old in Oakland County. So at least these allegations may appear to the court a pattern here that may be escalating in degree of depravity, for lack of a better word. I feel he's a danger to the community, particularly with our minor children. And I'm going to remand him in the custody of Wayne County Jail in this matter. Probable cause will be May 16th, preliminary examination May 23rd, both in front of Judge Jacquet. Is there anything else either counsel wants to put on the record?
Sir, anything you say right now can and will be used against you. It's all part of the record. You do have a right to speak, and I can't stop you, but I highly advise that you exercise your right to remain silent. But if you have a right to speak.
All right, step aside there, Mr. Kennedy.
Your Honor, can I have those court dates one more time?
Mr. Rainey, he's not in possession of handguns, firearms, or other dangerous weapons. All right, what's your name, sir?
William Wilkes.
What's your name?
William Wilkes.
All right, this is case number 250-565-7802. People said Michigan versus William Wilkes. Appearances, please.
Lisa Coyle appearing on behalf of the people.
Jessica Scheib on behalf of Mr. Wilkes, who has formal reading, understands his constitutional rights, and stands mute.
Court on not guilty plea on behalf of Mr. Wilkes. Bond recommendation from the people.
Your Honor, this is the KPS. On April 7th of this month, he failed to appear. There's a $30,000 cash bond by
Is this a
judge.
felony case? This is a,
Yes,
and what, I'm sorry, this is something I overlooked. What judge was that? Was that Judge
Giles. Yes, Judge Giles.
Okay, all right. Given that the judges are in a conference, I'm going to continue that capious bond set by Judge Giles. Actually, my understanding, none of the judges are available. So bond redetermination will be May 12th in front of Chief Judge McConaughey. Public cause May 16th. Preliminary examination May 23rd, and that is a $30,000 cash capious bond set by Judge Giles. Is that correct?
Yeah.
Okay. Is there anything else either counsel wants to put on the record?
No.
Your Honor, I know that the court is not able to change the bond and the judges are not here, but for the record, my client indicates that he was in Macomb County Jail for a height of violation for this case. And so the capious would have been no fault of his own. He actually came from Macomb County Jail to the Detroit Detention Center, so he hasn't even been out. I know that the court usually can't change that, but I know that sometimes there are exceptions if it can be verified that he was in custody and that the capious was no fault of his own. And I believe the Detroit Detention Center can verify that.
I'm don't doubt anything you said, Ms. Shive, but under my directive, I have no authority to change the bond in these capious matters, regardless of good cause, which may be seen or not. That's got to be addressed on Monday with Chief Judge McConaughey. Is there anything else you want to put on the record, ma'am?
I just see my client's hand up and your, sir, anything you say right now can and will be used against you. It's all part of the record. This magistrate does not have the authority to change the bond for you, but you do have a right to speak. So if there's anything that you want to say, go ahead, but there's prosecutors on and it's part of the record.
I just want to say, I am in here on house arrest. I'm in here on
Sir.
house.
Hey, sir, step aside. Just step aside. Step aside. Next one.
Thanks for watching. Make sure to hit that like and subscribe button for more crazy court hearings like this one.